Hey, how are you doing? And we are carrying on now with our series talking about trusts and the three certainties. So before, we've covered this one's going to be about the certainties of objects. So we had done the certainty of intention, the intention of creating trust, meaning what we are really wanting to do. And you don't have to have anything written down. You don't actually have to talk like in any specific language, as long as the intention was very clear, where we had Paul versus Constance, when literally just the words, as much your money as mine, created that trust, and therefore there was a valid trust. Nobody was qualified to do it. They didn't have anything written down. There wasn't any special words that made it magically a trust. It is a trust, and that's all there is to it. Then we went over the subject matter, so the things, the assets, the valuables that are actually being protected, and how they must be identifiable, very specifically identifiable. So that's probably well, it is something that just like one of my things that I really find that vitally important, especially when we look at that London Wine Company, literally just not dividing and segregating the assets completely made the trust fail, ruined the trust. So anyway, let's move on to the objects, which seems a bit of a weird thing, but I mean, they're talking about beneficiaries. Okay, so we're going to go over the slides, we're going to describe it, and again, it's all about case law. I'm only talking about law, I'm only talking about facts. I've got no opinions on it whatsoever. It's just what I read in the law, and it's the law books, and that's what it is. Now, everyone can have their own opinion, but when we're sitting there, this is case law that's set. And once it's set under stare decisis, the lower courts have to follow the precedent set. And if they're following it, then you better follow it as well, or you're not going to be able to actually show that you have a trust, be it a written one, expressed, or even just a verbal one, like we had with the Paul versus Constance. So let me get the slides up on here, and then we'll share them on the screen. I'll get myself out of the way, and there we go, full screen. So the case law that we're going to talk about for this one is called McPhail versus Doulton, 1970, and it's all about the certainty of objects, which, as I've just said, there is the beneficiaries of any particular trust. So what it means, the understanding of the certainty of objects, you're looking at like who is the beneficiaries. Okay, that's really what it means. So this is vitally important in trust law, because we have to follow the three certainties. Whenever any trust's going to be going into a court, the first thing they're going to look at, or any like sort of like enforcement process or administration process, they're going to look at the three certainties. Have you made sure you covered the three certainties? And obviously this is one of them, the certainty of objects, i.e. the beneficiaries. So there's two trusts that we're going to look at, as in the when it comes to the objects. That's fixed trusts and discretionary trusts. We're only looking at the certainty of objects when it means, when it's coming to those two types of trusts. And again, the case law that we're going to go over and explain is McPhail versus Doulton. You can all research it. It's there, and then this is what you must be following when you're looking at creating your own trusts, and when you're looking at understanding the certainty of objects, how you make sure that you've got the certainty of objects clear as it states in the law. So the McPhail versus Doulton case will show you, and then from that case you will have what we call the legal testing and the ruling, which comes from Lord Wilberforce. But we'll go over that as we go through the trusts. But just so you know, that's what we're going to be doing. Going through the trust, going through the slides. All right. So what is the certainty of objects? The definition of it, the explanation and meaning of it, the certainty of objects is the beneficiaries of a trust, and they must be identifiable. This ensures that the trust can be administered and enforced. What we mean by administered and enforced is, well, what are you going to do with the benefits of a trust? Usually there will be assets that are either going to be bricks and mortar that you're going to be able to have a benefit from, be living in them, but it might actually be a trust fund where there's going to be like cash available, which is the Paul versus Constance case. That was just only talking about cash. But the beneficiaries, the ones that are being named as the objects, well, they have to actually, you must know who they are, or they're not going to get any benefit from it. So it's vitally important that you have that covered. Now, the legal requirement, this is a legal requirement because it's one of the 3 certainties that is required to form a valid trust. As I just mentioned before, they are going to check the 3 certainties before they look at anything else. If you haven't got the 3 certainties in place, they're just going to stop there anyway. You have no valid trust. So we have obviously what we're talking about here, the certainty of objects, and that goes alongside the certainty of intention I just mentioned about the Paul versus Constance, and also the subject matter, which is when we're talking about the case of the London Wine Company. Now, the practicality of it all is, if it's unclear who benefits, I've just said that, if we don't know who's supposed to actually get the benefits of the trust, then what's going to happen? Nobody can have them. So the trustees will not be able to do the job properly. Well, they'll not be able to execute their duties. They'll not be able to follow what it says in the actual deed. And then, right, when we're looking at a court scenario, they're going to have to be able to know and correctly identify who it is or which person it is that qualifies. And I mean a person because it will have to be either a class of persons, as we're going to go over, or an identifiable person, depending on if that's either fixed or discretionary. But let's explain that a bit more. So fixed versus discretionary. So a fixed trust, in fixed trust, all the beneficiaries and their entitlements are clearly listed. The certainty of objects must be exact and exhaustive. So they just say we've got like Fred Henry Smith and Jenny Jane Smith. They're going to be the beneficiaries that are clearly named in the certainty of objects. They are there as the beneficiaries. It isn't discretionary. It is fixed. It can only be them two and no other. Hope that makes sense. Pretty clear. On a discretionary trust, the trustees choose from what we call a class of potential beneficiaries. So certainty, it's about the class of definition. It's not an exhaustive list, but it's got to be identifiable in that class, which is what I just mentioned before, is the is it or is it not rules where they actually do it, which is what I was talking about, the Lord Wilberforce thing, and yes, they do not have to be named, but also it has to be a class that's easily identifiable, and it doesn't sort of like be too vague. If it's the more vagueness that we're using, then the less definition that there will be, and the more risk you are running of not having a valid trust. So the legal challenge lies in defining what the class is, and it has to be clear enough so that it's always possible for them to say, yes, well, you or these people are in that class. This side, those people cannot be in that class, which is or is not a question from Lord Wilberforce. All right, so let's continue. So let's have a look at the case law where this lies. And as I said from the beginning, everyone can have an opinion. You can do and you can say and you can think whatever you like. I'm not interested in anything except facts and law. And the case law that we are talking about, which shows what is 100% that everyone must follow. Like it or not, it is what the law is. You either do it or you don't do it. So we've gone on and stated nobody has to have any qualification for to create their own trust. You can actually go and get a template and create your own trust, putting all of your own details in. Nobody has to be qualified to do that, as in the Paul v. Constance very, very clearly shows. Now, the once you're actually creating it, you just got to make sure you follow the 3 certainties, and then even boiling down to this last one, and we are going to make sure we follow the McPhail versus Doulton case law of 1970. So let's have a look at the background, what actually was going on. So there's a guy called Mr. Barden, we'll say my pronunciation. He created a trust for the benefit of his staff, his ex-staff, and their relatives and dependents. Right. So he owned the company, so he was wanting to have it for his staff, but then his ex-staff and relatives and the dependents. So that's quite, well, it could be quite a large group of people. Now, there obviously was a dispute, which is why we have the case law coming out. So the issue was whether the class of beneficiaries was too uncertain to be valid under trust law. So when it gets to a bigger class of people, is that too many? Is it too vague? Is it too wide? Is it like not really getting it down to who it could or could not be? Now, originally, right, the trust was actually put down as a failure. There's not a valid trust. There is too vague in who is going to be the actual beneficiary with the words that they use. And what I mean by that is like the terms that they use, like relatives and dependents. This is what the court originally actually said. All right, so it did actually say, no, it's a failure. But this is what I was talking about before. Then Lord Wilberforce, he says, well, look, I don't really agree with this. Well, let's have a test. So is or is not. And that is the actual test. So what he said from the House of Lords, before it used to be the House of Lords, now it's the Supreme Court, but you've got the House of Lords held that it was sufficient that it could be said of any person whether they were or were not in this class. So you would ask them the question, are you a dependent of this man or woman? Yes or no? Are you a relative? Yes or no? So it actually was quite a narrow group of people when you put it that way, and you were asking the question in that way. And that's what Lord Wilberforce decided. And I think it's absolutely correct as well. And this actually showed that this was a class that was definitely described. Therefore, not vague, not vague, too vague that it wouldn't be a trust. So then it was reversed, and they said, yes, this case here, and this is what we all go off now, McPhail versus Doulton, to make sure that we cover the certainty of objects. So the test is or is not test replaced the need for total complete lists. And, this is it. The discretionary trusts made such trusts more workable in modern law, much more flexibility, but as well, still making sure that they were completely lawful and legal. And as long as you have that class defined, and we've got some good examples of it in the other work as well, the other slides that we're going to be doing, showing you the wording that you can use. It's specific wording that you can use, so you don't have to say things like what he said. Mr. Barden has to be someone who worked here or their dependents or relatives. So, it made it far more flexible and far more easy and straightforward to create and administer a discretionary trust. And as long as you're doing it so that you use the correct words, which we've got the terms ourselves, we're going to show you later, so that you can see that the class of definition is very clear and conceptually certain. So again, we cover the certainty of objects on our three certainties. So as I just said, it makes it so you have a lot more flexibility. The case mark, the move towards practicality. So it's actually making it more practical to be able to operate these trusts in law, especially for discretionary arrangements. And what that means as well, by the way, discretionary means that the trustees have the discretion to decide who in that class is going to be the beneficiary. So it emphasized that clarity of concept rather than exactitude is what matters for trust enforceability. So as long as you're covering all of those aspects of it, it can be broader, but make sure that you're still covering it so that it's clear and has clarity. So certainty of objects, conclusion is flexibility enough. Well, yeah, it is. So conceptual clarity replace exact lists in trust law. Yes, McPhail versus Doulton revolutionized trust law. So you can accept now and you can set it up, use the words correctly, and you have a class-based certainty over an exhaustive identification or specific individual names. So today, courts balance practicality with clarity. So the class, I know a lot of very large beneficiary states, like, you know, like a large amounts of value that are held in certain offshore trusts for some of the other ones that I know, and they are all only on a class. They never ever have a specific name written in as a beneficiary. So hopefully that has cleared that up, and it will show as we continue going through and sharing the knowledge of the trusts. And remember again, okay, you can all have your own opinion. It's totally up to you what anybody thinks, says, and do. I will only go off facts and law, and we will use the case law that's written in all of the top law books. And that's all there is to it, and that's all we will tell you, and that's all we will share, and it just makes it very, very clear. So hang on, then just wait till I get this out of here as well. I'm going to remove that there, bring myself back in. Hang on, the seats falling to pieces here. So just to go over, we've been covering the certainties of the trusts. So we had the three certainties to make sure you got a valid trust. So they had like the certainty of intention, we had the certainty of subject matter, and there we have the certainty of objects. So we're talking about the certainty of intention. What was it you're meaning to do? And if as long as you've got it, and like I said, in the Paul versus Constance, this money is as much yours as mine, them words are clear. And I had witnesses to him saying the words, right? So in other words, that was a trust. It was created as a trust. And, you know, even when the wife, because they were still married, tried to take the money, then it stopped it. And there you go. So that was a clear intention, the certainty of intention. So on the certainty of subject matter, and what we're saying, because the wine company hadn't actually segregated and then identified what was and what wasn't belonging to a potential customer, they said, well, we've sold them, prove it. Which ones are? Not a number, nothing had reference numbers on, wasn't segregated, it was all in the same warehouse. Big problem, the trust failed. And then on here, when you've got McPhail versus Doulton, then working there with like Lord Wilberforce, and is or is not right the questions, then that shows you that you could have a class of beneficiaries rather than specific names. You don't have to have the names in. All right, so you're not having to actually show. So when people are saying, well, if somebody can be settlor, trustee, and beneficiary, there's never going to be a name on the beneficiary anyway. You should always be using a class when you're creating this type of trust, the discretionary trust, where the trustees will have, obviously it has to be set out in the actual deed and the laws and the rules that you put in there, but there you go. So we will make sure that we use a class for a discretionary private trust. Hopefully that's clear, and we'll put that with the other videos, and you enjoyed that one. So we'll see you all on the next one. Take care.